Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if a union represents an employee who, in terms of the union's constitution, is not entitled to be a member of that union. Now, the age-old question of whether an aggrieved employee may be represented in litigation proceedings by any union has been the subject of some uncertainty. Fortunately, a dispute between AFGRI Animal Feeds and NUMSA finally put this debate to bed, which dispute is the subject matter of this episode. The dispute between AFGRI Animal Feeds and NUMSA began when the employer AFGRI dismissed several employees during December 2017 for participating in an unprotected strike. The strike followed AFGRI's refusal to afford NUMSA organizational rights. NUMSA, whose members is restricted to the metal industry, represented these employees despite their ineligibility under its own constitution. The dispute remained unresolved at the CCMA, and when the dispute was heard in the Labour Court, the employer objected to NUMSA's standing on the ground that its constitution prohibited the dismissed employees who were employed in the animal feeds industry from becoming members of NUMSA. The Labour Court initially ruled in favour of AFGRI, declaring that NUMSA lacked the legal standing to represent the employees. NUMSA appealed to the Labour Appeal Court. The Labour Appeal Court reversed the decision of the Labour Court, citing the importance of fairness and access to justice in dismissal disputes. Essentially, the Labour Appeal Court drew a distinction between a union's ability to exercise organizational rights and its ability to represent employees in individual disputes. The Labour Appeal Court held that NUMSA could represent the employees in the unfair dismissal case, even if they were not eligible for membership under NUMSA's constitution. The employer was not happy with this outcome and therefore appealed the decision of the Labour Appeal Court to the Constitutional Court. The Constitutional Court held that a trade union has no authority to represent dismissed employees who are precluded from becoming members of the union in terms of the union's constitution. The Constitutional Court held that one of the effects of legal personality is that a trade union may perform any act in law which its constitution requires or permits it to do. Where a trade union performs any act that deviates from or is contrary to its constitution, that act is beyond its powers and thus is null and void. So colleagues, it is now clear that the right of employees to be represented by trade unions of their choice in both arbitration and labour court proceedings is not unfettered. A trade union must confine membership to employees in industries that accord with its own constitution. Where employees fall outside of the scope of a particular industry, the trade union can neither admit such employees as members nor represent them in litigious proceedings. That then brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email me at vapia@massconsulting.co.za. Till next time, bye-bye.